Hello and welcome. Today, we're going to share with you the top tips every employer needs to know to protect your benefit plan from costly compliance mistakes. If you're an HR director, benefit plan administrator, or if you advise self-funded employers on their benefit plans, this webinar you can't miss. Why? Because compliance isn't just a box to check. It's your best defense to protect yourself, your company, or your clients against Department of Labor audits and potential lawsuits from plan enrollees. Hi, I'm Jennifer Austin, Senior Director of Strategic Marketing and Employer Engagement here at the Alliance, where we help you self-fund smart. As I just mentioned, compliance goes beyond just completing the paperwork. As regulations continue to change, you can think of this next hour as your roadmap for what to do to avoid an audit and what to do if you find yourself in one. In today's session, we'll explore what triggers a Department of Labor audit, if you're faced with an audit, what to expect, and what the Department of Labor is really looking for, and what you can do now to be prepared, and finally, how to minimize the risk. Before we get started, I want to take a moment to make sure you're comfortable with our updated webinar platform. For those of you joining us live, you can resize or close all the boxes, including the video screen and slides. There's also a chat box and emoji buttons. Please use the chat feature to ask your questions, and we'll answer as many as we can at the end of today's program. If you're finding value in today's content, give us a thumbs up or a heart. It lets us know what's resonating with you. A copy of today's presentation slides is available to download from the resources box on your screen. And the recorded video of the event will also be available for on-demand viewing from the events page of our website and via our YouTube channel. We will email a link to all attendees next week when it's available. Finally, I wanted to take a moment to thank Delta Dental and National Cooperative RX for their ongoing sponsorship and welcome one of our new webinar sponsors, MH Imaging. MH Imaging is one of our preferred value providers, a provider that has good service at great prices. To learn more about how each of these partners can help your self-funded plan, click on their links in the resources box on your screen. We truly appreciate all our sponsors' support. It allows us to continue bringing these valuable programs to you, our employers and partners. Today, I'd like to welcome back John Barlament, one of our most popular and informative webinar presenters. John is an employee benefits attorney who works with employers and health plan vendors on various legal issues with a focus on health and welfare plans. He is recognized as a national leader in these constantly changing areas of law. He's been interviewed by and quoted in leading publications, including the Wall Street Journal. Welcome, John.
Thanks, Jennifer. And thanks, everyone, for being here today. Happy to talk about those topics that Jennifer alluded to. Again, we're going to kind of walk through the what, the who, the why of DOL audits. What are they focusing on? Primarily focused on health and welfare plans. We'll throw in a couple bullet points on retirement plans, but mainly focused on health and welfare plans here today. And we'll conclude with some practical steps where if you do become subject to a governmental audit, whether Department of Labor, HHS, IRS, CMS, somebody else, again, some general philosophies, some general tips to kind of walk you through. In terms of, what we should be thinking about here, I mean, why are we subject to these rules? What should we be thinking about? How does all this work? In terms of how a fiduciary prepares for an audit or investigation before they're aware of it, there's two things to focus on. First of all, criminal investigations and civil investigations. The vast majority of the investigations that are out there are civil and focus on, I would say, procedural prudence, kind of the governance of the plan, prohibited transactions, and payments of benefits. So we'll talk a little bit more about procedural prudence. It's probably the most important thing that's out there from a benefits perspective. The Department of Labor, the IRS, HHS, CMS, they all want to see you sort of taking reasonable, proactive steps to address compliance issues. When we talk about that, we'll talk about having like a benefits committee to kind of monitor laws. One of the questions I know we got ahead of time was, what's the best way to stay up to speed on these kinds of changes in laws? benefits committees, we love them. They're very helpful, kind of monitoring things. So the assignment gets, reduced down to one particular group of people to kind of comply with these rules. We think that that's helpful. In terms of who, again, enforces these, again, kind of the alphabet soup of regulators out there, DOL, EBSA, IRS, HHS, CMS. All of them can conduct audits. The Department of Labor is one that we see the most often. I've worked with clients on IRS audits. I've worked with them on HHS audits, on HIPAA privacy stuff, but far and away, the Department of Labor is the most important one. State enforcement is possible too for non-ERISA plans. So if we have any non-ERISA plans out there, you should kind of think through that too. What laws and risks do employers or plan sponsors face? Who's subject to them? What should you be concerned about? And how can you reduce their risk? Again, these are kind of the high-level things that we're going to talk through in this presentation. In terms of the what piece of it, what benefit laws should we focus on? The short answer is all of them, right? So that's the easy answer is, of course, we're going to try to comply with all of them. But from an importance perspective, and just from a human bandwidth perspective, clients can really only focus on certain things, right? And so I think the most important one is certainly ERISA. ERISA is kind of the grandfather of all these rules, came out 50 years ago, 1974. It really kind of sets the groundwork for everything else. So, for example, if you fail to comply with, say, the mental health parity rules, the MAPIA rules, that actually could be a violation of ERISA too, because you're supposed to prudently administer the plan. One aspect of prudently administering the plan is complying with all these other, other laws which are out there. So again, ERISA is by far the most important piece. And if you have a benefits committee, and if you have like new members on the benefits committee, and if you haven't trained them on what ERISA is or what MAPIA is, CA, things like that, it's a good idea to do a little bit of internal training. For some clients, I do like an annual fiduciary update. And then when a new person comes in, we do a mini fiduciary training, like 15 minutes, just a very basic overview of what ERISA is. That's a really good idea to at least make sure that the key folks understand kind of the basics. Mental health parity is probably the second most important one right now. We'll show some statistics, but probably the majority of the things that the Department of Labor is auditing right now relate to mental health parity, especially the non-quantitative treatment limitations, the NQTL rules. These are violations of rules where the Department of Labor might claim that you're sort of picking on mental health benefits. Maybe you have a prior authorization requirement that only applies to mental health, doesn't apply to medical surgical. You would basically be picking on mental health benefits. That'd be a clear-cut violation of these NQTL rules. And again, that's an important one. Consolidated Appropriations Act from December of 2020 it contains about a dozen different provisions in it, the gag clause rules. We'll talk about them. Some of them are still not in effect, believe it or not, such as some new air ambulance reporting. I would think we might see some movement on that one next year. But in general, those are kind of the hottest of the hot button items. What else is kind of lingering out there? Some of these go back decades. The Affordable Care Act goes back to 2010. We continue to get questions about that. There's always something kind of new going on there. COBRA from the mid 80s. And again, COBRA errors are very common. It's not unusual at all for an employer to forget to send out a COBRA form or, provide incorrect COBRA coverage, maybe provide coverage too long beyond what you're supposed to. So again, COBRA is an oldie but a goodie. HIPAA privacy rules, HIPAA security rules remain important. Actually, just a few weeks ago, there were some new proposed HIPAA security rules that came out. We're not going to cover those today. They're only proposed. We don't know if they'll be finalized, but it was a nice little reminder, a little poke that, hey, HIPAA is out there. You should keep up with those obligations. Form 5500, it's a form that you file with the federal government. It basically tells the federal government how many plans you have, how many people are in the plan, things like that. Why is it important? We believe that failures to properly file the 5500 or if you file it, but you file it incorrectly, it can trigger red flags. We think that we've seen audits basically get triggered by 5,500 violations. There are a whole grab bag of other laws out there, the Women's Health and Cancer Rights Act, GINA wellness rules, things like that. For retirement plans, you have a whole nother layer of Internal Revenue Code, IRS specific requirements, and then retirement plan specific ERISA terms. Again, we're not going to focus on those today, but I want to just remind you of that too. And of course, in the retirement plan context, the dollar amounts can be even higher, especially when you start talking about like litigation over fees, for example. Let's see here. And I'm just double checking. Okay. Let's see here. So in terms of who should focus on these laws. So again, kind of a whole smorgasbord of laws. Who should focus on these rules? Well, ERISA requires that various rules must be fulfilled. For example, you have to have a plan administrator. Plan administrators are generally in charge of complying with these laws. So, who's in charge of COBRA? It's going to be the plan administrator. Who's in charge of HIPAA? Going to be the plan administrator. That plan administrator role is going to, in general, be in charge of all these laws. Who is the plan administrator? That's a different question. In general, we like to see clients appoint somebody, a human being, or a committee of human beings to be the plan administrator. That way, they know what their responsibilities are. They know what they're supposed to be doing. Everybody else knows, what their lanes are too. So if you haven't formally adopted or identified a plan administrator, it's a good idea to do that. You can do it in a wrap plan. You could do it in a health plan document. You can do it in a standalone document. It doesn't really matter all that much where you make that designation, as long as you make that designation. Name fiduciaries. You also have to have named fiduciaries. So if the Department of Labor wants to come and audit somebody, they often start with the named fiduciary. And again, that's very important to do that. And we also note, and I think we may have a slide coming up on this too, we generally prefer a committee. If you don't appoint a committee, basically the Department of Labor says that the responsibility sits at the highest level within the organization. So if your organization has a board of directors, let's say, and if you don't appoint a committee, that named fiduciary responsibility kind of sits at the top level. Most boards do not want to be named fiduciaries. Most boards have no idea what's going on with the health plan, the dental plan, the short-term disability, long-term disability. They would probably be horrified to think that they are responsible for all these different, retirement plans, health plans, et cetera. So generally, you want to push that responsibility down to a smaller group of people who can, again, kind of monitor it. Who else? Functional fiduciaries, those who handle plan assets or decide final internal appeals, should be worried because they can have fiduciary responsibility. Co-fiduciary liability is possible also. And again, if you are working at the TPA who may decide final appeals, they will be a fiduciary. How could you get mixed up in that? Well, let's suppose that they're not doing a good job. You know that they're not doing a good job, and you're failing to monitor them. You're failing to kind of follow up on their errors. You could have co-fiduciary liability, even though you thought you outsourced the responsibility to the TPA. Who serves in these roles? Again, I mentioned it kind of starts at the highest level, and then you kind of work your way down. So again, an individual or a benefits committee is a good idea. I kind of prefer the benefits committee. Giving responsibility to just one individual is a little bit risky and kind of not the preferred approach there. Committees are very common in the retirement plan context. I would say the majority of our clients, if not, it's certainly not all of our clients, but the vast majority of our clients have retirement plan committees. Probably 60% of our clients have health and welfare plan committees. That is kind of the gold standard and what you should think about doing. But I will say that it's not universally adopted. We don't have 100% of our clients doing that. It is a good idea, though, especially given some recent lawsuits on health plan fees that we'll be talking about a little bit more later. Okay, who else should focus on these laws? Definitely have to coordinate with internal resources. When we talk about having a committee, who sits on the committee? Oftentimes it's someone from the legal department, maybe somebody from finance, HR, the benefits group, risk management. So kind of think through these different issues. But the minute that I say that you should bring in these additional groups and coordinate with them, then you also have to be sensitive to other possible concerns. Like, for example, While we want someone from HR usually on these committees, we oftentimes don't want it to be the head of HR, because we're worried that maybe the head of HR will see a $1 million health plan claim come through on an appeal, and the head of HR will vote against it, and then the head of HR will kind of know who that $1 million appeal relates to, and then that person's performance drops off at work, and then the head of HR has to fire that person. Will that person turn around and say, well, hey, you're firing me because you sit on this committee, you knew I incurred $1 million claim, that's why you're secretly picking on me. So again, you do have to be kind of cognizant of those sort of competing business interests. I've seen that pop up on the finance side of things, where a finance person is on there, and then the finance person will say, well, this will impact the bonuses that the CEO gets. And it's like, well, wait a minute, that really shouldn't be a consideration when you're wearing your ERISA fiduciary hat. So again, be cognizant of those sorts of issues. Why should we focus on these laws? So again, not just who, but why. Many possible adverse results of these laws are just ignored. You shouldn't be surprised by that. There can be monetary penalties. And although I hate to even say this because I don't want to engage in fear mongering, you should know fiduciaries of ERISA covered plans can have personal liability. So in theory, if you are not satisfying your fiduciary duties under ERISA, you could lose your home, your savings accounts, things like that. Now, with that being said, that almost never happens, because as a general matter, the plan sponsor or employer will pay for penalties. If you are acting on behalf of the employer is designating you to take on these responsibilities, usually the employer will specifically indemnify you. Usually that indemnification comes through a committee charter. So again, that's another reason to have a benefits committee. The members of the committee will want the employer to indemnify them. So again, that's another reason why it's good to kind of set it up from a formal perspective there. The specific monetary penalties can vary by law. Kind of a common one is basically $100 per day per affected individual, which really adds up. That's about $36,500 per year per affected individual. And again, if you have 100 people who are impacted, 200 people, you take 100 times 36,500, and the numbers really start to get big. Federal government regularly collects, $1 billion, $2 billion, $3 billion per year in terms of penalties here. So again, it can be significant dollars. Criminal actions are certainly unusual. In fiscal year 2023, the Department of Labor had referred over, I think, 196 criminal investigations, and 77 individuals were found or pled guilty of violations of various benefit laws. So, 77 individuals, 196. That's not completely unprecedented. But again, most of those were, I'd say, more on the egregious side of things here. Other actions, wall of shame. If you have a major HIPAA breach, the U.S. Department of Health and Human Services has kind of a list of everybody who had a major HIPAA breach. Why? It's perhaps in part to kind of shame the industry and say, hey, employers, if you have these breaches, TPAs, insurers, PBMs, if you have these breaches, we're going to kind of call you out, and we're going to put some pressure on you in terms of public embarrassment. You could also have employee relations issues or union complaints here too. Other reasons to focus on this, retroactive processing of claims. Not last year, in 2023, UMR, who's a big TPA, got sued in Wisconsin by the Department of Labor. The Department of Labor saying that UMR, on behalf of its employer-sponsored group health plan clients, was improperly processing certain claims, and they want UMR to go all the way back to 2015 to have those claims be reprocessed. That's a long time if you think about it. 8 years, 9 years, 10 years. It's complicated. The people, UMR may have lost some of those clients, and how do you go back? How do you still have the data going back 7, 8, 9 years? So it can be a real annoyance. Really a lot of lift there to kind of reprocess claims. MAPIA, there's some new MAPIA regulations from September 2024. We covered those in a separate Alliance webinar. Definitely check that out if you're not familiar with it. But one of the new penalties that the regulators are proposing is that If your NQTL analysis is insufficient, then you might be barred from using that NQTL. And so that might mean, for example, that your health plan could not have a medical necessity exclusion. You could not have an experimental or investigational exclusion. That could be very expensive. Normally, health plans only pay for medically necessary services. If your health plan participants get wind of the fact that, hey, it's wide open, the buffet is open here, there is no medical necessity requirement, there's no experimental investigational limitation, they could in theory rack up a lot of expenses, cosmetic procedures, things like that, that normally maybe your plan wouldn't have covered, but now you have to cover. So that is worrisome. In addition, it's possible that the plan could lose its tax qualified status, like HRAs, for example, could lose their tax qualified status if they pay improper claims. And of course, you may want to do these kind of tests to kind of prove that you are following these rules. All right, so that's kind of the what and the why here, but how do we focus on these laws? Great question. It's a tough thing to do because there are so many different benefit laws out there. I'd say that the first step is trying to understand what laws apply to you. If your plan is subject to ERISA, you generally focus on state laws. You generally do not focus on state laws. There can be exceptions, but in general, ERISA is going to preempt many of the rules which are out there. For example, when I talk about state laws, I say many, but not all. Many of you have seen that there was a change in terms of the IRS Form 1095s that go out to employees. Now you generally don't have to do that, but there are 4 or 5 states out there which require those forms to be distributed. And so the question has come up, we're an ERISA covered plan. Do we still have to send out the notices to our California employees, to our Washington employees, folks like that? And I've told some clients, I think you probably should. You have an ERISA preemption argument that you don't have to follow the state laws, but it's just kind of unclear at this point. So again, normally ERISA covered plans really don't focus very much on state laws, but there can be some exceptions there. How else to focus on these laws? Look at your plan documents, look at your SPDs. Courts sort of view these as contracts. Look at your forms, look at your notices that you go out. And one of the handouts here that the Alliance is making available is it's about a 12 to 15 page kind of list of different notices. And so you should have access to that. So, go through it, look through it and say, hey, do we have all these notices in place? When was the last time they were updated? Has the law changed? Who's in charge of distributing these notices? What's the process? Kind of think through it step by step in terms of, monitoring, updating these things, et cetera. Vendors, your vendors as a practical matter are going to handle a lot of this, right? If you're self-funded, you're going to have a third-party administrator, you're going to have a pharmacy benefit manager, so make sure that they're competent, do regular RFPs, document that process, keep those papers for years, maybe a couple decades to kind of prove that you went through this process of prudently hiring vendors in this area. Make sure that from a contractual perspective, that the vendors are going to follow these laws as they apply to you, not as they apply to them. Because again, a lot of these rules don't apply to vendors. They apply to group health plans, meaning that your health plan has to comply, but in theory, your vendor doesn't. And so what you want to do is by contract, force them to follow these rules, even though they don't technically, a lot of times, apply to them. And one of the things that we've been trying to push on recently too is that you should try to require that some of these terms apply even after the contract. So if you terminated somebody in January 1, 2025, a vendor, you still may get DWell audits, you still may get inquiries, things like that. So try to keep those contracts in place in some situations, even post-termination. Other kind of ways to focus on these laws, I mentioned ERISA being sort of the granddaddy, the most important one. Here's a very brief rundown on the basic ERISA fiduciary duty rules. Again, these are the highest known laws, the highest known obligations under the law. So these are the most important things. If you walked away with one thing from this presentation, think about these items here on this particular slide. Duty of loyalty, making sure that when you act on behalf of the plan participants and beneficiaries. And let me give one quick example of this. a few years ago, it's probably about 10 years ago now, I was talking to a client and we were talking about this duty of loyalty and how folks should, think about the interests of the plan participants. And the person, they had one person who heard health plan appeals. The health plan appeal lady said to me, well, hey, I don't know if this is an issue, but I get paid a bonus every time I deny a health plan claim. So every time she denied a claim, she personally pocketed money. And that's how the employer set it up, as a way of kind of controlling health plan costs, to give her, a reason to be stringent here. That, I think, is a breach of the duty of loyalty. I mean, how can you be focused on administering the plan if every time you deny a claim, you get more money? So to me, that's kind of an odd situation. But the general principle is still kind of sitting out there. Duty of care, again, very important. What would a prudent expert do? Basically, what a prudent person who's very familiar with this matter, how would they handle that situation? And if you think that you are not prudent enough, that you haven't, had enough experience, hire experts. You should hire experts, hire an expert TPA, hire an expert consultant, an expert lawyer, folks like that, to kind of help you get up to that speed. Duty to diversify plan investments, usually more on the retirement plan side, can apply for funded or trust-paid health plans. Duty to follow the written plan documents, duty to avoid prohibited transactions, and then duties related to co-fiduciaries I talked about before, in terms of kind of monitoring your co-fiduciaries. All right, how else to focus on these laws? Well, the Department of Labor has published some helpful guidance here. Take it for what it's worth. Some of these are a little bit old, but they do have something called the Compliance Assistance Guide on Health Benefits. It's a nice document. It's about 150, 170 pages long. Talks about all these different laws which are out there. So again, do take a look at that one. There's a self-compliance tool for MAPIA that is a little bit outdated. I think it came out in 2021. The DOL has said that they're updating it. We hope that they'll update it soon, but at least if you want to see how the rules kind of worked a couple of years ago before the September 2024 regs, you can definitely check that out. EBSA, the Employee Benefits Security Administration, which is kind of the division within the DOL who handles this, has an enforcement manual with various forms and kind of processes that DOL uses in an audit. If you're curious, take a look at it. Form 5500 instructions. Again, most people have to file Form 5500 if you have a self-funded group health plan. Take a look at those instructions. Make sure that you're complying with them. Go through them line by line if you have to make sure that you understand what you're doing there. How else to focus on these laws? Well, if errors occur, it's relatively easy to correct retirement plan errors. There's kind of nice guidance, something called the EPCRS, Employee Plans Compliance Resolution System, that you can follow to fix retirement plan errors. In contrast, in the health plan space, it's very difficult and sometimes impossible to correct health plan errors. That's unfortunate because errors are going to happen. So how do we fix them? So the general rule that I follow comes actually from the COBRA rules. The COBRA rules are, I think, one of the few federal health and welfare laws that actually talk about how to fix an error. And what those rules say is that you need to put the affected plan enrollee in the same position he or she would have been in had the error not occurred, which makes sense, right? If a participant would have gotten a particular benefit, but for your error, but for your TPA or PBM's error, then you kind of have to reverse the error and put them back in the same spot that they would have been at. That's a nice guide. We tend to use that guide in terms of correcting plan errors. So I think that's a helpful general approach in that situation. Other sort of ways of focusing on them, there's something called the Voluntary Fiduciary Correction Program. So if you think that you've breached your fiduciary duties, there's a way of kind of dealing with that. Also, for late Form 5500 filings, there's a way of kind of correcting that too. It might also be possible to reach out to a federal regulator and kind of on the side or sort of in a different manner correct these types of errors. How else should we be thinking about these laws? I think the main way that clients get audited is through complaints. Right now, I am actively working on 2 different Department of Labor audits. Both of them, I think, stemmed from participant complaints. So trying to address participant complaints is a really nice kind of low hanging fruit, if you will. If you're like, how do we kind of minimize the risk? Dealing with participant complaints is really, really a good idea. So, trying to cut it off at the pass before they get so frustrated that they feel like they have to go to the federal government and complain. Now, just because they're complaining doesn't mean they're right. So you may have to draw a line. Maybe your plan just doesn't cover something that they want to be covered. So, there is a limit, but do what you can to, kind of address those issues up front. I think is very helpful in terms of talking to them about their concerns. What else, how else can we focus on this? I think we could look at what the DOL is prioritizing. And the DOL has said that these are the hot topics that it's enforcing. So they have a website. I just mentioned it in the last slide. They have health enforcement initiatives which focus on various ERISA provisions, including Women's Health and Cancer Rights Act, Newborns and Mothers Health Protection Act, GINA. So those are important, but there are 3 national initiatives. First, the mental health parity and QTL rules. So again, as I mentioned, we had a whole, hour-long presentation for the Alliance a couple of months ago on this. Do take a look at those NQTL rules. Again, this is like number 1 on their list, the Department of Labor's list. So if you're trying to figure out, okay, what is the number 1 thing we should focus on here in terms of hot topics? Again, it's probably mental health parity. And again, you should also take care of the benefits committee. I mean, there's other important things, but if you were worried, if you already have the benefits committee in place and you're like, okay, what next? NQTL rules, I think, is going to be the most important thing here. Doing that NQTL comparative analysis, and then effective for plan, you're starting January 1, 2025. So it just started. You also have to do a formal fiduciary certification that a prudent process was followed to analyze those rules. So somebody within your organization, somebody's going to have to put their personal name on the line and certify that they believe that a prudent process was followed. So if there's going to be an audit in the future, the DOL is going to know who to call. I think they're going to ask, okay, who signed that fiduciary certification form? So it's going to put some pressure on people within, every self-funded employer's organization to kind of deal with that. It will take some additional time. Just so you know, we have been reaching out to TPAs and PBMs. We do a lot of this work. They are updating their template documents. So I think it'll probably be first quarter or second quarter 2025 before they finish those. And then that'll cause folks like us to kind of poke at them, prod at them, identify weaknesses, identify gaps. So it's gonna take most of 2025 to kind of work through those things, I think. In addition, I tried to pull some data here of kind of how often mental health parity gets investigated. For fiscal year 2022, EBSA conducted 145 total health plan investigations. 86 of those involved mental health parity. So over half of all their investigations in fiscal year 2022 involved mental health parity. So it's a very hot topic for them. CMS, Center for Medicare and Medicaid Services, they regulate non-ERISA group health plans. They did 5 mental health parity inquiries in the same time period. So that kind of shows you that DOL is leading the charge, basically, even though CMS and IRS do have some enforcement authority here too. All right, what else? Coverage of emergency room services under the ACA. This has been a hot topic where maybe a plan participant will go on into an emergency room and will not really have a true emergency, but something that they think is an emergency. And so then the question is, are they really sorry, frog in my throat here. Are they really being denied coverage for an emergency when they shouldn't be denied coverage? So I think the takeaway for employers is talk to your TPAs about this, and again, put it into the contract that they're going to comply with these rules. The third sort of national initiative here is service provider self-dealing, kind of undisclosed, hidden, or excessive fees. This is a tough one. You should press on your vendors to make sure that you're understanding all the fees which they're obtaining from you, both direct and indirect. So again, press on that. It's it's a tough situation because again, they are usually reluctant to try to disclose all their compensation. So again, do take a look at it. Press on your vendors there. How do you press against your vendors? Maybe look back to some prior 2016 proposed regulations that were later withdrawn, which would have required additional disclosures. There have been some DOL lawsuits in this area. Just in November of 2024, the DOL brought a lawsuit against a TPA seeking $40 million in undisclosed fees. In January 2024, the DOL sued Blue Cross Blue Shield in Minnesota over $66 million in taxes, which were allegedly improperly taken from employers. So again, the dollar amounts do get to be very high there. Other sort of fee issues, fee concerns, many of you have probably heard about this, but in 2024, we saw something very unusual. Previously, we had seen plaintiffs' lawyers bringing lawsuits in the retirement plan space saying fees were too high. And in 2024, we started to see it in the health plan space. Johnson & Johnson and Wells Fargo both got sued. There were a couple other plan sponsors who were threatened too within the last 12 to 18 months. So basically the argument is that, hey, plan sponsors, you are not minding the ship. You're not paying attention to the fees that your vendors are charging in the health plan space. That's a very significant issue here, I think, in terms of trying to make sure that you are monitoring this. So again, try to do some due diligence, push back. It can be difficult to get this information. There's a Bricklayers case, Bricklayers Local 1 out in Connecticut, sued it's Blue Cross Blue Shield TPA, basically saying, hey, we need to understand the fees. Blue Cross said, no, we're not going to tell you. And it went all the way to an actual court battle over disclosures of that may have been a little bit more on the data side, but I think they were going to use the data to figure out the fees. So anyways, it can be a tough one because again, vendors maybe don't want to disclose everything, but plan sponsors, I think, should press on it and document it. So whatever you're doing here, keep a record of it. So if you ever get sued or the DOL ever investigates you, you can trot out a whole paper, stack of documents and say, hey, here's what we did. Here's the emails where we're pressing on this. Here's what the emails we're pressing on that, et cetera. All right. Other kind of common compliance issues, not mentioned on that last DOL website, but we have seen cybersecurity issues been growing. There was a September 2024 clarification that certain best practices that definitely applied to retirement plans, and it was unclear whether they applied to health and welfare plans. The September clarification said, yes, they do apply. So in theory, you should have cybersecurity policies and procedures in place really for all of your health and welfare plans, not just the retirement plans, not just your major medical. It seems to be broad. So that is a little bit of a risk. We, in the past, have seen some DOL inquiries here and some questions there. So do take a look at it. It's more of a hot topic, especially, again, because of that clarification and then the proposed HIPAA security rules from a couple weeks ago. That whole area is kind of heating up again. Grandfathered health plans. I would say 90% plus of our clients do not have a grandfathered health plan anymore. Under the Affordable Care Act, you kind of maintain your plan as it was in March of 2010 and then avoid certain requirements that applied. What we're seeing now is for one of my DOL audits, the DOL is basically saying we want every communication going back to March 2010 forward. We want to verify that you really didn't lose your grandfather plan status. And that's hard, right? I mean, do you really have communications going back 14, 15 years here? So if you are trying to maintain your grandfather health plan status, keep these papers kind of indefinitely. You're going to keep them forever, basically. Other common compliance issues this time of year, I get this question all the time. What about an employee who forgets to enroll? So, you probably had open enrollment in October or November, maybe December. Someone just messed up. They just dropped the ball. Or maybe they were out on a leave or something like that. So they missed the cutoff. Now we're into January. Can we let them join the plan? We usually tell people that there are some options there if for someone who missed open enrollment. You might, for example, be able to allow them to pay on an after-tax basis, not a pre-tax basis for the coverage. But whatever you do, you should probably be consistent. The question I have at the end is, what if the employee is the CEO versus the janitor, basically? again, you should try to be consistent in terms of how you administer those benefit plans. Other common compliance issues, HIPAA breaches or security violations, again, still fairly common. You should update your HIPAA policies and procedures if you haven't done so. Note that the last time you probably had to do that was about 20 years ago, 2004, 2005. So if you haven't touched it in 20 years, you probably should have been updating it yearly. You certainly would need to update it now. Non-discrimination testing, we do see clients do that. That's probably a good idea. What if forms or notices are not distributed timely? Again, try to get them out as kind of the best focus there. Also, when you are updating your plan document SPD, think about certain things to include in there, like a form selection provision. So you can basically say, hey, if you're going to bring a lawsuit against us, it has to be in Milwaukee County, Wisconsin. That way, if somebody retires to Florida and they want to sue you in Florida, you can say, no, you're going to sue us here where our headquarters are, for example. So think about ways to kind of improve your SPDs, time limits to bring lawsuits, make sure that the plan fiduciaries have discretion, et cetera. Wellness plan class action lawsuits have been growing. You should look at that from a risk perspective. Basically, many plaintiffs are saying that there was not an effective opportunity to kind of avoid some of these wellness plan requirements which were out there. All right, other steps to kind of prepare and get ready here. Let's talk about kind of some nitty-gritty sort of things to keep in mind. Operational issues, record keeping. Again, make sure you have contracts with your service providers, make sure that they're updated, make sure that you have your other plan documents, SPDs, and that they're updated. Confirm that the plan is paying consistent with the contract. Look for any gag clauses. The CAA from a few years ago generally prohibits a group health plan from entering into a contract with a TPA, PBM, or other vendor if it contains restrictions on the data that the plan sponsor can receive. And we just got new guidance from Monday on this. So there's some new FAQs. Some of these provisions are kind of surprising. Like the first one says that it also includes indirect contractual restrictions, including downstream ones. So let's suppose that you are Acme Company, you have a contract with your TPA, and that contract with the TPA maybe doesn't have any gag clauses in it. What this new FAQ from Monday is saying is if that TPA has contracts with various healthcare providers or other vendors, and if those have gag clauses in them, then you are liable for that indirect contract. So you would have no idea that these contracts exist. You're not a party to the contracts, but you can still be liable if they have gag clauses in them. That is the exact opposite of what I was told last time I checked with the federal government on this. And so I think that most plans probably don't really have that in place right now. So again, go back to your vendors, try and do it quickly. They released it on Monday. It was effective on Monday. And so they didn't really give us much, well, they didn't give us any time to comply. So do take a look at that. I read the regs, the FAQs as saying that as long as you get it kind of cleaned up by the end of the year, when you certify again, I think you can probably certify that you're compliant, but it's a little bit unclear on that particular point. All right, other kind of things to think about here in terms of fiduciary insurance policies. Again, I mentioned before about if you are a fiduciary, you're going to want some kind of assurance that you aren't going to lose your house, basically. So it's very common to have fiduciary insurance policies. Again, you should probably have that in place. If you're on the benefits committee, talk to the employer about it. Make sure that you have this kind of coverage. If you were to ever be actually audited by DWEL, let's kind of change gears here and talk about this for a second. What would you expect? First of all, you normally get a letter, a formal letter from the Department of Labor to the plan administrator. You may get a phone call ahead of time. I've seen that happen too. The letter will kind of give you a heads up about where this is going. They'll probably request various documents or narrowly focus on one aspect of plan administration. We'll talk about the time periods. Don't be afraid to ask clarifying questions. A lot of times we'll see where they come out and ask for a whole bunch of information, and then we're able to kind of narrow the scope of it, that kind of inquiry. It's very common to request an extension of time to produce documents. A lot of times they will ask for things within, say, 30 days. We've seen 10 days, we've seen 15 days. But again, you can usually push back and say, hey, this is a lot of information to gather. And, if it's true, they're usually pretty good. I found, they're pretty good folks in general. And so do try to push back, again, if you think that it's too burdensome. You can ask the auditor about the scope of the investigation, the issues that are under review. They probably won't tell you, to be blunt. They don't like to reveal that. They'll say some general stuff. The plan is under investigation, things like that. But they usually won't give you a ton of information there. What else? The document requests, again, can encompass tens of thousands of pages. It's a lot to manage. So normally we encourage a plan sponsor to appoint a point person to gather the documents, serve as one contact with the DOL, and then that one contact can kind of coordinate everything. We as counsel often interact with that point person. So we kind of talk to the client ahead of time, that point person ahead of time, about what to expect. There may be ways of trying to identify certain communications which are subject to attorney-client privilege. Like, for example, when we do mental health parity and QTL work, we stamp our work product with attorney-client privilege. Why do we do that? To try to shield, questions later on. If we identify weaknesses, we don't necessarily want those weaknesses being found. Types of documents that the DOL may ask for, and again, because they may ask for them, you should go back and double check. Do we have all these documents in place? Plan documents, trust documents if it's funded. Do you have any policies and procedures? A lot of times there may be procedures on, how to establish whether something is a quadro on the retirement plan side, or, what's our procedure for administering our benefits committee, things like that. SPDs, meeting minutes. If you have a committee, it's normal to have somebody take minutes of the meetings because there will be like formal votes, and it's good to have minutes. It establishes kind of what went on, but the Department of Labor may ask for those meeting minutes. Look at them, see if there's anything that might be attorney-client privilege that can be redacted from those minutes. Actuarial valuations, consultant reports, financial statements, Form 5500s are very common things that the DOL will ask for here. What else? Contracts with associated fee schedules. Again, fee issues are big deals. Data files of participants. I was actually on a phone call with a Department of Labor investigator yesterday. The DOL is talking to the PBM of a client, and we had a spreadsheet that was open of all the denied claims under the prescription drug plan. And the DOL was literally asking the PBM representative, okay, what does this mean? This column is headed, REJ. Does that mean rejected? What does this mean? So they're literally kind of going through it, sort of point by point to understand the data underlying this, which is interesting because plan sponsors can't always get access to that data, but if the DOL asks for it, normally the vendors will provide it at that point. Other things, expense reimbursements, investment manager reports, if you have investments, vendor audits, benefit payments, other things that they may ask for. What do you do with all this? Well, if you gather all these documents, and again, it could be thousands of pages, do try to organize them in a usable format in the same order as the DOL requests. If you send it to them in a sloppy manner, they're just going to turn around and say, hey, you got to reorganize this. We don't understand it. It'll create confusion. It'll create bad will. It'll make it more adversarial. In general, we try to be, I would say, cooperative with the DOL. We don't try to be overly helpful. We try to, give them what they're asking for, but without, going beyond what they're asking for is kind of a good approach, I'd say. Once in the hand of the DOL, public may have access to it, so you may want to try to identify things which are proprietary and seek some kind of exception there. You should also identify the documents in a cover letter to the DOL, advising them of what's in there, and we usually talk to the clients about what to expect. There can be a significant period of time that may pass between the initial production of documents and when you hear back from the DOL. Don't be happy. Don't view a 6-month or 9-month delay as, hey, we're in the all clear. but also don't view it as it's really bad. They must be, filing a lawsuit against us. It just takes time. So don't kind of view it, either way. You may get follow-up requests for additional documentation. That's totally normal. Interviews. Interviews are tricky. You may be interviewed, and it's technically voluntary, but we usually see clients agree to it. Counsel usually can be present, so usually we are present, and we will try to kind of steer things or try to clarify things, maybe is a better way of saying it. Sometimes the DOL investigator will ask very broad questions, and we try to kind of say, well, what do you mean by that? Are you referring to this or referring to that? So, be careful in those interviews. Try to, be clear, don't speculate, ask for clarifications if something is unclear, just kind of treat it that way. And I think that's probably a good way of handling it. After the interview, after they've looked at everything, what can happen? Well, they could issue a no violation letter. That's fantastic. Say, no, there's really nothing to see here. That is not normal. Normally they find something that is wrong. They may send you a voluntary compliance notice letter, VCNL, where they say, hey, we've identified these issues and we think that, you need to, pay this amount. Normally it's a very short turnaround, about 10 days to kind of analyze that and either agree or disagree with that. Most of the time clients, they say, hey, yeah, we probably have some exposure here. Let's just pay this. Let's just get it over with. So that's kind of the normal sort of approach. Again, other kind of tips, again, be cooperative, don't be confrontational or argumentative, be accurate. If you're not sure of something, say, I'm not sure of something. And then consider making changes in your policies. If the DOL identifies a problem, if it's a problem, fix it. Don't wait for the DOL, 12 months later to say you should fix it, because then you may have to reprocess all these claims anyways. So, try to be cooperative, try to be proactive, involve the other professionals, things like that. Participants and beneficiaries, they may become aware of the investigation, consider whether you should coordinate with them. And then again, talk to the DOL auditor in advance about any issues that have popped up. After the investigation is over, what should you do? Treat it as a lessons learned. Have a debrief with your folks. Try to figure out, okay, what happened? Why were we not monitoring this? Why, what were the gaps? What were the errors? And then, of course, you may have to actually settle it. Penalties are common, in this kind of context. They're usually not huge. In theory, they could be large, but the DOL almost never seeks the maximum penalty, which is good. So again, normally, if you do agree to pay it, you'll get a closing letter and saying basically everything is taken care of. All right, finally, other key takeaways, again, high level, what did we just kind of talk about? Keep up to date with the best practices, monitor these laws, identify who is responsible for complying with these laws, kind of think through how would this look on an audit. Hopefully you never do get audited, but if you do, be cooperative, but not overly cooperative, I guess, and kind of be prepared for it. All right, that was a lot. Jennifer, do we have any questions here?
Yes, thank you again, John, for being with us today. It's such an important topic and a great way to get a jump start on the year. I do just want to do a quick reminder that disclosure list that you mentioned is available to download from the resources box. And we did get quite a few questions, and thank you to those who submitted them in advance. One of the questions we received was, how do these compliance concerns impact an on-site clinic? Do any of these agencies have on-site clinics in their crosshairs?
Yeah, so it's a great question. So on-site clinics can be viewed as a health plan, because the definition of health plan is basically any kind of employer-sponsored arrangement that provides or pays for medical care. So on-site clinics can be viewed as ERISA covered plans. You may have to have an SPD for your on-site clinic plan. To avoid that, you may want to build it into your major medical plan. The problem with doing that, though, is you may offer your on-site clinic to every one of your employees, but not every one of your employees will be in your major medical plan. So the short answer is, yeah, they basically are likely to be an ERISA covered plan unless you limit it to just like first aid. So you should deal with it. Crosshairs, I'd say no. Of all the audits that I've ever seen, I don't think I've seen a single one on on-site clinics. So in general, yeah, they are subject to it, but it's not a priority from an enforcement perspective.
Okay. And that kind of goes into one of the other questions we got. What are the key dates for benefit plan compliance? Do we have that listed out? I don't know that we do in this document.
Yeah. So in that separate handout, we talk about like notices and the different effective dates, for notices and things like that. So that's probably as close as you can come. In terms of other laws, they're just going to vary. Like, for example, we mentioned the new gig clause FAQs that came out on Monday. They were effective Monday. So those are effective Monday. Air ambulance reporting will probably get some guidance here in 2025. I would expect those to be effective in 2026. Mental health parity, certain ones became effective 1/1/2025, but other pieces of it become effective 1/1/2026. So in the benefits compliance space, everything has its own due date, basically. So it's a lot to keep track of.
So there is no easy answer, is what I just heard.
Well, an answer only a lawyer could love. Yeah, exactly.
Yeah. One of the other questions is, what is the most common thing that organizations are missing in the realm of compliance?
Yeah, that's a great question. And, it certainly does vary. I would say that the number one compliance issue is probably dealing with those mental health parity rules. The occasional errors, like you forget to send out a COBRA form, you forget to send out a HIPAA notice of privacy practices. Those pop up. They just happen. And again, most of the time clients are like, okay, send them a new COBRA notice, send them a HIPAA notice, things like that. So those are just kind of, a steady drumbeat of occasional errors are going to happen. And you try to do what you can, but you can't eliminate everything. But I'd say mental health parity is probably the most important one. Another one that I think clients are still working through is in April of last year, there were some new reproductive healthcare regs under the HIPAA privacy rules. You should probably be updating your business associate agreements or policies and procedures. I'm not extremely worried about those, but that should be on your to-do list here, I'd say, in first quarter 2025.
And I know we have more questions, but I'm going to ask one that came in through the chat recently. How do you anticipate settlements on the J&J and Wells Fargo suits and others to follow to compare to the fiduciary breach lawsuits we've seen on the retirement side?
Yeah, it's totally fascinating. The whole, class action lawsuits. The J&J one, they may have picked the wrong lead plaintiff, to be blunt. There's some questions about whether lead plaintiff ever paid an excessive fee. The Wells Fargo one seems a little bit better constructed from the plaintiff's perspective, better constructed. It's going to be hard to prove damages, though. I think in the retirement plan context, it's easier to prove damages. There are thousands of cases out there. You can kind of look back to what courts have ruled on. So I think the potential risk is probably still smaller here because we don't have thousands of cases we can refer to. It's going to be harder to calculate damages. But nevertheless, it's a concern.
Thank you so much. That wraps up today's event. I really appreciate you joining us today and sharing your important knowledge on this topic. If you need additional resources, please reach out to your account executive here at the Alliance. We have experience in benefit plan design and are happy to assist you. Or if you're not a member and you want to learn more, please reach out to business development. Remember to download the handout we mentioned earlier. If you would like a copy of any of the handouts and are not able to download them during today's session, please send an email to events@the-alliance.org and we'll happily email you a copy. If you're watching this webinar live, you can claim CE credit by clicking on the View Certificate buttons on your screen or in the Engagement Tools drop-down box in the top right-hand corner of your screen. And finally, we'd love to see you in person. Stop by and say hello if you're attending any of these upcoming events. And be sure to save the date and join us in person April 23rd for our Spring Symposium in Madison. Thank you for joining us today. And remember, when you think of the Alliance, think self-funding smart. Take care.